A very good afternoon to Honorable Vice Chancellor, sir, and all the dignitaries present here. Good afternoon to Sudarshan Professor Sarvarama ma'am for his blessings. And Meenakshi, thanks to you for inviting me. Today's topic is very important because in the pandemic scenario, when we are discussing the judicial relationship with the health issues and the responsibility of the legal professionals in that scenario. So that is very much discussed not only at the national level, but also international level. So today's discussion, I think this will be a very iceberg quality in the field of law. So I hope the participants, they are fully prepared with their papers, and I will not take too much time before the presentations. After the presentations, I would like to give my views on the papers. So with the permission of Honorable Sudarshan Verma ma'am, I would like to invite the participants to present their papers and give their opinions.
Yes.
Thank you, ma'am.
Abhishek, please go ahead.
Thank you so much, sir.
Please start the session.
First of all, I invite Shridul Gupta to present the paper titled Contours of Right to Health. Shridul Gupta. Yeah.
Thank you so much, ma'am.
Thank
you so much indeed. Okay, I'll just increase. Thank you so much, ma'am.
Ma'am,
if you could just make me a cohort, so I just need to share my PPT.
Ma'am.
Yes, Akshay.
We hope your nations and all the other participants to the waiting room so that you can easily, Shridul sir can easily present his paper. So can we have your permission now? Thank you very much.
Yes.
Thank you very much.
Shridul Gupta, Mr. Shridul Gupta, please unmute yourself.
Thank you so much, ma'am. Respected Professor Dr. Sudarshan Verma, ma'am, Chairperson of the present technical session. Respected Professor Dr. Abhishek Tiwari, Co-Chair of the present technical session. The Chairperson of the organizing committee. Respected members of the organizing committee. My senior colleagues present in this August gathering, and all the members present here, a very, very warm good afternoon to all of you. I'll be presenting a paper on the topic, Contours of Right to Health. Ma'am, just require an access so that I can share my PPT. It still shows that has been disabled.
Akshat, please assist Mr. Shridul Gupta.
Ma'am, just give us a second. We are just solving his problem.
Just make me a co-host. I'll be able to share. I hope my PPT is, maybe able to share the PPT right now.
Yes, sir.
Okay. Thank you so much for the confirmation. The topic of my presentation is Contours of right to health. Presently, or in the recent past, whenever we surf the internet on health issues or read the daily newspaper referencing to the health news, or whenever we flip some news channel, we come across the issues regarding global health challenges. Challenges which every country is facing globally or worldwide. The importance of health, it can be understood from the fact that provisions regarding health, they have not only been included under the Constitution, our Constitution, but also amongst various international instruments. The importance of health can also be estimated from the fact that despite the fact that our architects of the Constitution, they had not included the right to health as a fundamental right in our Constitution, yet our judiciary included it as an implicit and an indispensable part under Article 21 of the Constitution of India through its various judgments. Now, effective implementation of the right to health, it just requires a visionary national health policy, like we have presently our National Health Policy 2017, and a very enforceable, effective, a strong public healthcare law. Presently, there's no central public health law, although there are few states, Andhra Pradesh, notably Andhra Pradesh, Madhya Pradesh, Goa, Assam, these states have their own state-made health law. Now, health being a state subject, so the accessibility to the various health services or accessibility to the health infrastructure, it is totally dependent upon the state resources. It would be imperative if health is being made a subject in the concurrent list, so that each state can uniformly have the same share in the central pool. Now, right to health being so indispensable for the implementation of fundamental rights as well as other human rights, it is required that not only the provisions regarding right to health be included explicitly under Article 21 of the Constitution, but they should be effectively enforced as well, because they are concomitant to the realization of the real goals. As the World Health Organization defines the term health, it universally states that health is a state of complete physical, mental, and social well-being, and not just absence of any disease or infirmity. And the enjoyment of the highest attainable standard of health is one of the fundamental right, the basic right of every human being without distinction of that person's race, religion, his political views, and his economic or social conditions. So, right to health in simple term, it means basically everyone's right to have access to the healthcare services, including medicines, not just the surgical procedures, but the basic element that is being drugs or the medicines itself. And it should not cost a fortune. It should not lead to a financial burden on such person. This access to healthcare facilities in achieving the right to health is also based upon the realization, the achievement of factors including adequate nutritious food, clothing, shelter, clean drinking water, hygienic environment, sanitation and most importantly, safe working conditions. As rightly being held by Article 12 of the International Covenant of Economic, Social and Cultural Rights, right to health and its implementation, it requires availability of healthcare facilities. These healthcare facilities should be physically and economically accessible. They should be ethically and culturally acceptable, and good quality medicines with potency should be administered to all. Now, the importance of right to health can be adjudged from its recognition in various international instruments, as has been shared, including Article 25, Clause 1 of the UDHR, Universal Declaration of Human Rights, Article 12 of the International Convention on Economic, Social and Cultural Rights. Similarly, under the International Convention on Elimination of All Forms of Discrimination, Convention on Elimination of All Forms of Discrimination against Women, and the Convention on Right of Child. If we have a view regarding the recognition of right to health by our apex court itself, in the Vincent case, it was very aptly remarked by the Honorable Apex Court that the realization of right to health, it is based upon the fact that health is the foundation of all human activities. So in a welfare state, it is the obligation of the state to create conditions, and not just create, but create and sustain conditions which are congenial to good health. Similarly, in Permanent Katara case, regarding accident victims, Article 21, as adjudged by Honorable Supreme Court, Article 21, it clearly aims towards protection of human life, because protection of life, something which is very precious, which is very important, because once the life is lost, then status quo ante, it cannot be achieved, because resurrection, it is beyond the capacity of any person. Again, Calcutta electricity supply case, similarly, same views, that regarding the workman, Article 21 is his inherent basic fundamental right. Safe working condition to the workmen, medical care to such workmen, it is his right, not just a human right, but his fundamental right as well. Consumer Education Research Center, where the Honorable Supreme Court held that the expression life does not connote, or it does not mean merely animal existence, that you just survive, you breathe, but it is a facet, it is an integral part to live a meaningful, a dignified life. Paschim Banga Khet Mazdoor Committee case clearly states that state cannot avoid its obligation just on the ground of financial constraint. Just on the basis of financial constraint, one cannot tend to avoid its obligation regarding the effective implementation of the fundamental right, of the fundamental status being given to the right to health, which is an inalienable, indispensable part of Article 21 of the Constitution of India. Other notable judgments regarding Kirloskar brothers, Mohinder Singh Chawla case, Ram Lubhaya case, or the present case in which the Honorable Supreme Court suo motu took up these issues, it is being clearly adjudged by Honorable Supreme Court that right to health, it is the pith and substance of life. If this is not achieved, then everything crumbles up. So, I
Mr.
sum up.
Sradul,
Yes, please, sir.
yes. That was the request that you kindly sum up, because we
Yes,
have
sir.
6 minutes only.
Just summing up, just the last slide, sir. I just beg your pardon, last slide, sir. So I conclude by saying that right to health can be achieved by ensuring significant budgetary allocation for research in the field of medicine, research in the field of medical technologies, so that those diseases for which cure have not yet been found, they should be ensured that they are given a proper segment. Moreover, the medical care for the middle class, for people below the poverty line, it should be given priority. So it's a state obligation to respect, protect, and fulfill the right to health. And this responsibility, it vests equally on the three organs of the government, not just the judiciary itself, on all the three vital organs of the government. That's it, sir. Thank you so much.
Thank you so much, Mr. Sushil Gupta, for your presentation.
Welcome.
I would like to invite second presenter, Ms. Smriti Singh. The title of her research paper is Role of the World Health Organization in Enforcing Right to Health in the Pandemic Era. Smriti Singh and Divya Dwivedi. Thank you so much, for your presentation. I am going to invite second presenter, Ms. Smriti Singh.
Good afternoon. The title of my this is Smriti Singh. I am a research scholar in RML Lucknow, and the title of my presentation is Role of World Health Organization in Enforcing Right to Health in the Pandemic Era. Now, with time, the understanding of right to health has changed. Traditionally, health was a private matter, and absence of disease was considered as a benchmark for health. But now the times have changed. According to WHO, health is a state of complete physical, mental, and social well-being.
To interrupting you, do you have any PPT to share? Or...
No.
Okay, fine, you go on then.
Mental and social well-being, and not merely the absence of disease or infirmity. So we all know that since its inception, WHO has been responsible for controlling outbreaks of disease across borders. And especially when we analyze this COVID-19 situation, there can be no denying factor that COVID-19 has impacted the right to health in all its facets, be it about the mental health, be it about the physical health, or other aspects of health like nutrition and access to medicines and everything. So now it becomes important to analyze what the role of World Health Organization was in controlling this pandemic, so that the right to health could have been enforced. Now, WHO, it became aware of COVID-19 virus for the first time on December 31st, 2019, when its regional committee reported about an outbreak of a disease in Wuhan. And it was around 30th Jan, that is around after 1 month, that WHO declared COVID as a public health emergency of international concern. So we can see that around, it took World Health Organization around 1 month to realize that what is the magnitude of COVID-19 and to put into place travel restriction and other. But by the time World Health Organization declared COVID-19 to be a pandemic, it was too late, and already the COVID had spread to various parts of the world. So, but there was a lot of things that WHO did in the on the road of fighting with this pandemic, and the biggest role that was played by World Health Organization was dissemination of information and building coordination between various players of international communities. So it could be seen that time and again World Health Organization was bringing together various scientists, and all genome sequencing and everything was happening, and World Health Organization was bringing in coordination between various scientists, medical health communities, as well as the political leaders, so as to ensure that there is an international united response to this pandemic. Continuous advisories were also being issued about use of face mask and travel restrictions and everything that was being done. But as we all know that a lot of lives were lost in this pandemic, there was a huge economy was hugely hit during this pandemic. So therefore, it can be said that there were various reasons that WHO was not successful in containing this pandemic, and maybe this tragedy could have been avoided had WHO played a more progressive role in this. So here I am to analyze the reasons why the World Health Organization has failed in containing this pandemic. Now, World Health Organization has to be very cautious when it is designating a public health emergency of international concern. And it is so because it has implications on the global economy. So if a pandemic is declared, then the world economy gets affected, and obviously economic ramifications might come, the market might come down. So the Health Organization has to be very cautious. So, and even the country where this event originates, even that country does not want that this should be declared as a pandemic, because it can be seen that the country it shows a failure on the part of the country, and no country wants to show in the international community that we have failed. So like it was happening that China was continuously trying to hide the magnitude of this disease, and they were not letting the world know that what actually is happening in China. So this is one of the reasons. So there is no warning system that is in place, that in, like, suppose a individual event, it directly becomes a pandemic. There is no warning system in between where the constant monitoring is being done and the world community is put at an alarm that we need to monitor this situation. Secondly, we can see that due to the economic and political considerations, there was a delay in declaration of COVID-19 as a public health emergency of international concern. Now, the international health regulations, they mandate countries to report health risk, but there is no obligation on part of the countries to do so. So there is a international health regulations provide that you need to report any health risk that is occurring in your country, but there is no legal backing to it. So in case a country fails to report such a thing, there is no consequences in place. So right, like if it was happening that the world community is demanding accountability of China towards this pandemic, but there is no legal backing towards it. So World Health Organization does not have a legal backing towards the reporting mechanisms, and that is where there is a lacuna. Second, now there is no mechanism for World Health Organization to make its recommendations and policy mandatory. So, for example, the WHO was giving its travel advisories. It was telling about the use of face masks, medicines, but it was just recommendatory in nature. It was on the will of the countries whether they want to follow that advisory or not follow that advisory. So we can see when it is a pandemic like situation, it is what is needed is an international organization which coordinates various countries, and it should not be based on the will of the countries whether they want to abide by those recommendations or not. So it should have a binding recommendation should be there of World Health Organization. Now, why is all this happening? So I think the biggest root cause lies in the funding of the World Health Organization. So if we can see that around 14% of the funding of World Health Organizations comes from the assessed contributions of the member countries, but around 80% of this contribution is voluntary contribution. So voluntary contributions may be coming from countries, it may be coming from NGOs. So like Bill and Melinda Gates Foundation is giving a lot of contributions to World Health Organization. Also, USA is one of the biggest contributors to the World Health Organization, and we can see that what happened in this pandemic era, that USA threatened that they will not fund World Health Organization. And this is when China said that they will provide the funding. So there is a lot of political considerations being involved in a sensitive issue of right to health. So what is happening that all the agendas of WHO are based on the funding on the basis of who their funders are. And so the independence of World Health Organization is affected by its funding. So what is needed is a more independent mechanism to fund such an international organization, so that it can have an independent approach towards situation, and it does not have to depend on the fundings of or depend on the propaganda that is given by the major funders. So I would say that we have seen that there were hoarding of medicines and vaccines were being hoarded by the rich countries, and the poor countries were not having access to medicines and vaccines. And WHO couldn't do much about it, because obviously it was beyond its ambit to force countries to not hoard such a thing. So when a constitution of WHO provides that it will protect the right to health, I think in this pandemic era, WHO was not able to do so. And the reason being the structural and fundamental problems that exist in this international organization. We need a more legal backing towards WHO so as to make it a more effective and robust organization, because COVID is one first such situation that is happening. We cannot outrightly deny that there can be a future situation like this. So World Health Organization needs to be better prepared in order to enforce the right to health, and therefore it needs to have more autonomy, it needs to have more independence, and there has to be a legal backing towards the recommendations and actions that the World Health Organization is taking. Thank you.
Thank you so much, Ms. Smriti Singh, so sorry, and Ms. Divya Dwivedi for your presentations. Right. The next presenter we have is Ms. Sonakshi Marula Rawat and Jyoti Sarma. The title of the paper is Accessibility to Healthcare Facilities. Challenges to Social Justice System.
Good morning.
Over to you, Sonakshi Marula Rawat.
I'm just sharing my screen right now. Is it visible?
Yeah, it is. Carry on, Sonakshi.
Ma'am, am I audible?
You are audible.
Ma'am, I can't hear you.
Am I audible now?
I think we are audible. Let's start.
Yeah, you are audible.
Can we start?
Yeah, you can start. Yeah.
All right. Okay. Good afternoon, everyone. My name is Sonakshi and my co-author here, Jyoti. We're going to present a paper on COVID-19 pandemic, a ground reality of healthcare infrastructure in India. So when we talk about healthcare infrastructure, it is a basic support for the delivery of public health services activities. It also signifies the investments and the priority accorded to create the infrastructure in public and private sectors. In India, healthcare service comes under the state list and the concurrent list. The Union Ministry of Health and Family Welfare is the central authority that is responsible for the implementation of various programs and schemes. Now, healthcare in India is separated into two categories, that is the public healthcare and the private healthcare. And under the public healthcare, you are further dividing it into rural public healthcare and the urban public healthcare. Now, talking about the rural public healthcare, it has been designed in a three-tiered framework based on the established population norms. The subcenter is the most remote institution and serves as a primary point of interaction between the primary healthcare system and the community. Next, we have the subcenters, which are required to care for the men, women, and the children's fundamental health requirements. The public health centers are the second tier in the rural health care hierarchy to provide comprehensive, curative, and preventive care to rural population with a focus on preventive and promotional components. It serves as a referral center for 6 subcenters. And the third is the community health centers, forming the uppermost tier and are established and maintained by the state government. Now, each CSE is maintained by and staffed by four medical professionals, including a surgeon, a physician, a gynecologist, and a pediatrician. In the urban area, the healthcare infrastructure consists of community health centers and primary health centers. The urban primary health centers are in charge of the meeting and the population's primary health centers and the public health requirements. It is well positioned near the slums and the other similar habitations. It provides treatment through medical care, surgical facilities, and institutional delivery facilities based on the healthcare facilities. According to the stats in India, 75% of healthcare infrastructure is concentrated in the metropolitan regions, while 27% of the overall population resides. The remaining 73% of population lacks access to adequate healthcare centers, which is a major problem in India. 74% of Indian doctors serve the demands of the urban population. Now, talking about the points that will amplify on the rural-urban divide in India, firstly is the workforce shortage. Very well known that India is lagging behind according to the World Health Organization recommended doctor to patient ratio of 1 doctor per 1,000 people. A shortage of 6 lakh doctors, 1 million nurses, 2 lakh dental surgeons, and a large number of paramedical staff is faced by India. Second point being the doctor per patient ratio. The PHCs are short of more than 3,000 doctors with a shortage by 200% over the last 10 years. Since doctors are less in number, a patient is not always treated on time in the rural areas. Third point being the affordability. As we all know that health care is becoming increasingly expensive as technology advances. The facilities are likewise becoming more expensive. There are commission fees and most individuals are unaware of it. The rural population is saddled and crushing prices as a result of lack of efficient public healthcare facilities, pushing them back in poverty. There is also lower penetration of insurance, which is my fourth point. The expense of healthcare is higher for the rural population rather than the urban population, and the distribution is skewed towards the metropolitan regions. The ordinary rural Indian is unaware of the importance of healthcare programs, and they are put off signing for the insurance plans for a variety of reasons. Now, the fifth point being the improvement of the current state of existing primary healthcare centers, which is very, very important in today's time. There is also lack of medical stores in the rural areas, and people have to go long miles to even get the bare minimum medicines. There is also leveraged technology to provide healthcare. Technology may be used to improve access to healthcare in remote places and telemedicine services during the epidemic, due to which the government has improved the social distancing. Now, talking about the accessibility of healthcare facilities and the issues and challenges faced by the disabled people, very briefly, I would point out at the few challenges that is faced by them. Firstly, being the inability to wear the mask due to health risks, which is very, very well stated. Second, being the having to abide by healthcare visitor policies that excludes support persons. That is, many people who require the care of other support staff are not being able to give that or are not being provided by that. And there's also inaccessibility through telehealth. Like, for example, the blind people who are usually who are visually impaired, and the telehealth tools may not be compatible with certain programs that the government proposes. There are also negative consequences to social isolation because of limited interaction with the population. It can be difficult for those who are given extra care by the other people. And there are a few solutions to those problems which the disabled people face. And as you can see on your screens, I wouldn't be going much into that. We will be moving on to the policy efforts during the pandemic by my co-worker.
A lack of access to healthcare was a major challenge, especially when COVID-19 cases peaked. So such incidences paved way for many policies to come into play. So the current National Health Policy of 2017 is based on WHO's Health in All policies, and the most important feature of this policy is Swasth Nagrik Abhiyan, which means to provide healthcare service to all. This National Health Policy is in coordination with Ayushman Bharat, a flagship scheme of Government of India. Ayushman Bharat is intended to provide health insurance to poor, lower socio-economic group and people who can't afford health facilities. The scheme is made up of two interconnected components: one, a health and wellness center, and second, Pradhan Mantri Jan Arogya Yojana. Inequality in healthcare access remains a major problem due to rural, urban, and interstate disparities.
Excuse me, Jyoti, try to conclude yourself. Come on the conclusion.
Regarded as positive steps towards bringing up this gap. So such.
Please sum up. Please take care the time constant and sum up your presentation.
SSP. In these situations, these policies play a very important role. And COVID actually made us realize, are these policies sufficient? Are our healthcare infrastructure sufficient to face COVID-19 challenges? And due to this, government also made national task force in collaboration with the ICMR. This task force was was aimed to do research studies, clinical research, surveillance, and managing of drug and vaccines. Apart from these, telemedicine was something which was seen as a good option during COVID-19 pandemic, and people across the world opted for telemedicine. Even WHO promoted telemedicine, and many facilities were provided by telemedicine. Doctors would judge you via video call or phone call. But then telemedicine had a lot of issues, especially when in case of India, because a lot of people didn't have access to smartphones or good internet connection or good connectivity. So because of all these issues, telemedicine was not that successful in India the way it was internationally. Though it is time saving, it helps it is cost effective, reduces crowding in hospitals, but still it has a lot of disadvantages as well, just like technical issues. Everyone does not have access to smartphones and internet connectivity. Sometimes lack of physical examination can lead to wrong.
Meenakshi, I think the time is over.
Yeah.
They have
Having said
spoken
that,
for 10 minutes.
telemedicine can be served as a key solution
By the call.
infrastructure issues. Moving on to
Akshat, you there?
COVID-19 pandemic. The COVID-19 pandemic has highlighted long-standing structural cause of
Yes, ma'am.
health inequality.
Please tell Jyoti to conclude the conversation. She
Okay,
has
ma'am.
Inequalities between in terms of access of hospitals. Many hospitals.
Ma'am, your time is up. The judges are asking you for the sum up, so I'm very sorry, but yeah, your time is up.
please sum up, Jyoti, in 2 words. Or you have spoken more than 10 minutes, so chairperson and co-chairperson has requested you to conclude.
Sorry, we can't.
Okay, then we are moving to next presenter. So we have next presenter. Yeah, just a sec. Sir,
Just winding.
Meenakshi, ma'am, you are mute.
Meenakshi, unmute yourself. Meenakshi, unmute yourself. Meenakshi Kumari.
Yes, sir. I have unmuted. Am I audible, sir?
Yes, now perfectly audible.
So sorry, sir. Now we have next presenter, Ms. Sarita Sharma. The title of her paper is Climate Change, Sovereign Risk and Legal Risk, an Indian Triology. Over to you, Ms. Sarita Sharma.
Thank you, Meenakshi. Namaskar. Good afternoon, everyone. First of all, I thank Dr. Ram Manohar Lohia, National Law University, Lucknow, the chairperson, ma'am, Abhishek sir, the seminar committee, and all other concerns, individuals and institutions for giving me such a wonderful opportunity to express my thought on the subject emerging issues in law and justice in the perspective of globalization. My topic is climate change, sovereign risk, and legal risk, an Indian trilogy. This is a working paper, so I welcome any suggestions from any front. My topic is not directly connected to this theme, but it covers the issue related to financial health of nation that surely impact the right to health of the citizen too, because they, at one side there is a fundamental right, and the other the directive principles to oblige for by the state. Climate change is an important issue for policymakers globally. It can have a material impact on sovereign risk through direct, indirect impact on public finances, because it raises, it raises the cost of capital, particularly those belongs to the climate vulnerable countries, and it also threatens debt sustainability. Right now, I'm not going into the details of stats regarding India's public finance and its sovereign debts, etc., right now. But let me start with the fact that India is a developing country, and it is hitting the developing chart by holding a promising position towards becoming a developed nation. So the center point is that the policy maker globally, particularly in India, has to come with something that could make the nation climate-proof economies and public finances. Now, though, one of the question is, who are the stakeholders beside the stakeholders? I mean, who have to play significant role in mitigating the impact of climate change and further that climate change's impact on sovereign risk? For me, as what I have studied so far, the stakeholders are people, both as a citizen and as well as the contributor towards business sector. My paper shall discuss about the role played by climate change on sovereign risk, legal risk, and their intertwined impact. What impact they have? Basically, my papers deal with the risk to business due to climate change, with particular emphasis on sovereign risk and legal risk. I'll start with, there are a number of transmission channels through which climate change affects sovereign risk. This is what I'm talking through the literature which I have studied. My methodology of research is, right now, it's a doctrinal research. But I have concluded at the end that empirical research is very, very important. But back to this point, there are a number of transmission channels through which climate change affects sovereign risk. For example, the fiscal impact of climate-related natural disasters, fiscal consequences of adaptation and mitigation policies, macroeconomic impact of climate change, impact of climate risk on financial sector stability, international trade and capital flow dimensions. Last but not the least, the impact of climate change on political stability. These transmission channels are not independent of each other. Climate impacts can magnify the transmission of risk through multiple channels. The socio-economic and physical effect of climate change are multifaceted. And so that depends on the policies taken or not taken to mitigate and adapt to these risks. Few risks which I'm going to talk about is, first is physical risk. Sorry. Physical risk significantly impact economic activity, international commerce, employment, public finance, whether it is on the national or the international level. Second is the transition risk. Transition risk, for the best example is the energy transition. Recently, that net zero carbon, we know all about the net zero carbon emission pledge which we have taken. India is also one of the party there in the at the international forum. So the transition risk have a prominent impact on the economy because it affects the international climate policies, technological changes, and changing the consumption patterns. The implication of climate change for macro financial stability and sovereign risk are also going to be very material. One of the international report, which was on the basis of the empirical evidence, they used a sample of 40 developed and emerging economies, suggested with a significant certainty that there is a strong relationship between climate vulnerability, resilience, and the sovereign cost of capital. This study shows that the climate risk and resilience of these risks have significant impact on the cost of sovereign borrowings. I'm so sorry because my throat is a bit harsh. I apologize for that. Okay, next. In one shot, if I say that all branches of government will have to address climate related risk, particularly with that is related to sovereign risk.
Sarita,
yes, sir.
Kindly come to your conclusion.
Yes, I'm going to conclude in further 2 minutes, sir. Just give me 2 minutes only. Okay, The point is, when I'm talking about the sovereign risk, see, I talk physical threats, then there is an energy transition, and then there is a policy change. These three gives the impact to the sovereign risk. Now I'm talking about the fourth, because for the from the business phase, business point of view, the corporate point of view, businesses faces another evolving risk, and that is legal risk. This sovereign risk, because they have to go for the policies, there are voluminous legislation and everything, and for that there is going to be, and there is already, there are so many examples which shows that there is a legal risk. And what kind of that legal risk it may be? I'll give few examples, like common law tort, public nuisance, influencing future conduct of business by way of PILs, litigations. In fact, there are funding things. There are some negative impact on the business that's definitely going to have, because we are in the transition phase when we are talking about the climate change, and when we have to have a mitigating effect to mitigate that effect. In that case, there have to have some policies which should give bearing to the business sectors also. Because we know and we have seen, especially there are so many examples, particularly from the US, which is a developed country, and even there, secondly, the media coverages, they all do the things, they come with a point that from the humanitarian point of view, human law. But here, business prospect is also necessary to see, because to mitigate the sovereign risk, we have to push up the financial part, and that government not able to do it solely. Have to take a PPP, private public partnership need to be there. It is there, but if the policies keep remaining like this and there will be a litigation keep on going, then it's going to create a problem. So just saying something on theory will not work. This is, as I said earlier, this is a working paper and I'm working on this. So, and I personally feel that empirical research, particularly in India, need to be there. We have to know what are the factors. In this theory paper, I have the reasonings, I have the factors which are impacting, but to know the magnitude of impact, because once you know the magnitude of impact, then only you can have a practical implication of the things, and then you can have a proper policies to that regard. So I say that it is necessary to have a proper view, to have a proper analysis, and should have a empirical evidence so that we can go in a righter way. Thank you.
Thank you.
Thank you so much, Ms. Sarita Sharma. Now we have the next presenter, Muhammad Sufyan Khan. I invite you to present the paper titled Ensuring Climate Justice for All the International Green Politics, Interconnection Between Humanity and Nature in a Globalized World. Mr. Muhammad Sufyan Khan, over to you.
Please give the instruction in the beginning.
Okay, ma'am. Yes, Dr. Mirza Zunaid Beg or Muhammad Sufyan Khan, you have given 5 minutes to present your paper. Please follow the guideline. Thank you. Over to you, Muhammad Sufyan Khan.
Am I audible?
Yes, perfectly.
Very warm good afternoon to respected Chairperson Professor Dr. Sarita Sudarshan Verma ma'am, Professor Dr. Abhishek Tiwari sir, and all the organizers of this session. I, Muhammad Sufyan Khan, is going to present my paper on the topic Ensuring Climate Justice. Ensuring Climate Justice for All and International Green Politics.
Yes, sir. I have unmuted. Am I audible, sir?
Yes. And interconnection between humanity and nature in a globalized world. Climate justice for all. Climate change caused by human activity is part of a broader fundamental challenge of how to live sustainably and justly on Earth. The first acknowledged reference to the concept of climate justice appeared in a 1999 report titled Greenhouse Gangsters versus Climate Justice by the San Francisco-based Corporate Watch Group. The international green politics basically emphasizes on the politicization of environmental problems, and evidence of the damage and disruption they cause was undoubtedly a driving factor in the rise of green politics. In fact, the preamble of the UN Declaration on Human Rights also states that man is both creature and molder of his environment, which gives him physical substance and affords him the opportunity for intellectual, moral, social, and spiritual growth. Furthermore, there are various international green norms to ensure climate justice for all. Basically, the trial Smelter arbitration case, the Corfu Channel case, and the Lackness arbitration. Ramsar Convention on Wetlands of International Importance 1971, in Stockholm Declaration of 1972 as Magna Carta of Environment. Further, the UN Environment Programme, the Vienna Convention for the Protection of Ozone Layer 1985, and Montreal Protocol. Apart from this, there is the Rio Declaration on Environment and Development 1992, United Nations Framework Convention on Climate Change 1992, the International National People of Color Environmental Leadership Summit, and there is Bali Principle of Climate Justice, Kyoto Protocol of 1997. Apart from this, there is Paris Agreement 2015, the 26th UN Climate Change Conference of the Parties. Apart from this, the United Nations Framework Convention on Climate Change identifies action to protect the climate system as for the benefits of present and future generation of humankind. Classification of climate justice is based on the principle of equal treatment and fairness in society. Furthermore, to conclude my remark, it is the climate justice was embedded in international legal framework of fairness and equity. The world development models and the governments are built around the notions of fair justice without any kind of discrimination, now which needed to add the objective of fairness in well-being of people and ecological consideration of legal system in the form of climate justice. Thank you. Thank you, sir.
Thank you so much, Mohammed Sufyan Khan, sir, for your valuable words on climate justice. Now, I would like to invite Ms. Namrata. Yeah. I would like to invite Ms. Namrata.
Yes, ma'am.
Yeah, please present your paper, Ms. Namrata.
Yeah.
Over
I hope I am completely visible.
You are visible.
And audible.
Yeah, you are visible, Namrata.
Okay.
Over to you.
Yes, ma'am. Wait a minute. I'm presenting the screen.
Ms. Namrata, it's a humble request. Please limit your words in
Yeah.
your presentation.
Sure. I'm just presenting the screen. I hope it is visible to everyone.
Yes, Namrata, it is visible.
Okay. Okay. So, good afternoon, everyone. The theme, I am Namrata from Kids School of Law, pursuing third year of BBA LLB. So I am going to present on the theme that is ensuring climate justice for all issues and challenges. The title of my paper is Climate Justice, a Step to Ensure Green Economy. I will be dealing under the subtopics of what is climate justice, importance with respect to less emissions policy, international convention I have mentioned, and in this slide I have mentioned 5 important conventions, namely IPCC, Paris Agreement, UNCED, Kyoto Protocol, and Marpol Agreement, along with the equity component and the stance of India in this movement with respect to Supreme Court pronouncement. In my concluding remarks, I will be dealing with some recommendations for the challenge to overcome. Climate justice. So in the introduction, I have mentioned what is climate justice. So in my opinion, climate justice is more than a term, but a movement which is used for a global warming as an ethical and political issue rather than a purely environmental issue. It can have varying social, economic, public health, and other detrimental consequences of a deprived community. So nature provides exception to every rule, but development is inconceivable without change. So developing countries, while the developed countries are more developed and improved according to the quality of life of the people, but developing countries just like India, where the more emphasis is put on the economy rather than the environment. So without environment we cannot assure the climate justice. So importance of climate justice we can better understand with the effects of climate change in the middle income family in a developed country and differently with the poor migrant people in the developing country with respect to their quality of life. While we may understand environmental justice as a concept, we are likely to comprehend how environmental disparities are replaced in climate change and how racial injustice are when facing the full force of climate disasters. So we should care for less emissions. Those problems, the root cause is the emission of carbon dioxide gas. The climate sensitivity, which is defined as the global temperature rise following a doubling of CO2 concentration in the atmosphere compared to the pre-industrial level. If we know that climate sensitivity, it will help us estimate how much CO2 can emit and still stay below 2 degrees Celsius of warming as per Paris Agreement. So moving ahead with the international conventions, so these are the common principle which is being followed in most of the international conventions is common but differentiated responsibilities and respective capabilities, which can be denoted as CBDR plus RC with respect to the principle of capacity, which is denoted as RC. Its premises is that a country's fair climate contribution is determined by its previous emissions and wealth. In first, that is IPCC, which stands for Intergovernmental Panel on Climate Change. It was established in the year 1988, and it works at a regular interval for understanding the human-induced climate change and potential impacts and options for mitigation and adoption. Second is Paris Agreement, which is known as COP21 because it was formed in 1994. And India is one of the signatory, and and there are 55 countries. They have ratified that they will ratify covering the 55% of global emissions, and India, while solely responsible for 4% of global emission. And on 2nd of October, on this 147th birthday of Gandhiji, India became the 60th country to ratify it. So the third is the UNCED, which is the United Nations Conference on Environment and Development. While it dealt with individuals are at the focal point of sustainable development as well as the economic turn of events. Then the Kyoto Protocol, the name that doesn't need any introduction because it was ratified in 1997, and it based on the conventions and the standard and provisions as follows is extension based on the structure of the climate and their problems regarding it. It only binds to the wealthy countries with a burden under the domain of common good. The reduced greenhouse emission is the common responsibility, but developed countries must bear the responsibility because developing countries are more concerned about the economy rather than the ecology or the environment, which is a practical stance if we look into the practicality of this problem. Then the last is Marpol Convention, that is for the most international important convention to prevent the pollution of the marine environment by the ships during operational or intentional causes. It was adopted in the year 1973, while the reaction to a series of tanker incidents during the time period of 1976 to 1977, and then the convention contains the provisions in preventing and minimizing the ship pollution, both accidental and ordinary operations. So one of the important aspects that I have mentioned in my paper is equity component. The environmental justice is the fair treatment for all the people and freedom from discrimination in creation of policies and projects. The categorization of the climatic justice is found on the underlying premise of equal treatment and fairness in the society. As a result, they may take the responsibility for ensuring that
conclude within 1 minute. Namrata, conclude yourself.
Yes, sir. Yes, sir. I'm just doing that. So lastly, I would like to mention the India's stance that in the during this pandemic also, the Prime Minister Sri Narendra Modi planning to make climate justice for climate change for the centerpiece of 26th Conference of Parties, that is COP26. If we look into the judicial interference, then the Supreme Court established the reasonable threshold and the polluter pays norm in the Indian environmental law by the case of Vellore Citizen Welfare Forum versus Union of India of 1996. Then the mechanical stone crushing exercises that was being discussed by the MC Mehta versus Union of India, and the emphasis put on the Article 51A, that is the responsibility of every citizen to maintain and improve the natural environment. In my concluding remarks, I want to give some recommendation that climate change has been recognized as a threat to human rights. It's less apparent whether judges will be able to apply the existing law and precedent to those offenses. After all, the law was drafted without regard for the magnitude and the urgency of the climate change. Regarding the practical aspects of this problem, though developing country is more concerned about the economy rather than the environment, they should start looking at it because we are on a certain track. With this, I want to conclude my presentation, and I am very obliged to the organizing committee as well as the judge to providing me a great opportunity.
Thank you so much, Ms. Namrata Patel, for highlighting the importance of climate change. Now we have next presenter. I would like to invite Shakuntala Sangam to present the paper titled Right to Health in the Context of Sexual and Reproductive Health. Over to you, Ms. Shakuntala Sangam. Please unmute yourself, ma'am.
Okay, very good afternoon, sir. Abhishek sir and Sudarshan ma'am.
Good afternoon. Good afternoon.
Am I audible?
Good afternoon, ma'am. Good afternoon, ma'am.
Sorry,
So, yes.
ma'am. Dr. Shakuntala Sangam, ma'am. So sorry
Yes.
to.
Yes, Meenakshi, she is Dr. Shakuntala, ma'am, and she has been my batchmate also.
Okay, okay.
Thank you, sir. Thank you.
Thank you.
So here I have to present my paper. So may I share the screen? So my paper title is Right to Health in Context of Sexual and Reproductive Health Rights of Women in India, particularly. So here is the time scarcity. So in short, I'm going to discuss, not going in detail. So as an introductory part, when we talk about the right to health, that is the fundamental part of the human rights of our understanding of life and dignity. So right to enjoyment of highest attainable standard of physical and mental health, to give its full name, is not new. So internationally, when we talk about the right to health, so World Health Organization, whose preamble defines health as a state of complete physical, mental, and social well-being of not merely the absence of disease or infirmity. So preamble further states that the enjoyment of the highest attainment standard of health is one of the fundamental rights of every human being without distinction of race, religion, political belief, economic or social condition. So in the year 1948, Universal Declaration of Human Rights also mentioned health as a part of the right to an adequate standard of living, as in the under Article 25. So right to health was again recognized as a human right in 1966 in the International Covenant of Economic, Social and Cultural Rights. So here especially I am dealing with the reproductive and sexual health right, that is the part of the health right. So in continuation, reproductive health, sexual health have evolved into the distinct thematic area that includes physical, psychological, social and epidemiological aspects relating to sexuality and the linkage of these aspects, that is the material and social conditions that shapes access, experience and health conditions of the persons who experience as how the health outcomes of the diverse population both in our country or in any other state. So when we talk about the definition, so how it comes when it is under the definition or the conventions, the sexual health, it means the physical, emotional, psychological and social being. So it is also related with the sexuality that includes over the fertility, protection from sexuality transmitting disease and other aspects which are like, so it is provided that the well protection from the sexual person, stigma, censorship and the violence and the possibility of pleasurable or safe sexual experiences. So understanding of sexual health that evolves over time through the recognition of its interconnection with diverse thematic areas of human rights. So when we go to definition, so International Conference on Populations and Development, it gives a definition of the reproductive health atom, and within the definition it also includes the sexual health. Within the health, that the purpose of is that the enhancement of life of the person, relations, and not merely counseling and care related to reproductive and sexually transmitted disease. So all other things have been also included under this head. And in the report of International Conference on Population and Development, it says that the people are able to have a satisfying and the safe sex life, and they have the capability to reproduce of the freedom to decide it when, how, often to do so. So implicit in the last condition are the right to men and women to both informed and to have access to safe, effective, affordable and acceptable methods of the family planning of their choice. And the WHO also defines the sexual health as the state of physical, emotional, mental and social well-being in relation to the sexuality. So it is not merely the absence of disease, dysfunctional or infirmity. As I said earlier, so sexual health requires a positive and respectful approach to sexuality and sexual relationship, as well as the possibility of having pleasurable and safe sexual experiences, free from person, discrimination and violence. And in the year 1995, the Fourth World Conference on Women's Sexual Health found mention as an aspect of sexuality over which women's autonomy was recognized. Thus, the human rights of women include their right to have control over and decide freely and responsibility to matters related to their sexuality, including sexual and reproductive health. That would be free from coercion, discrimination and violence, as it has been repeated in all enactments and the organizations. And the Committee on Economic, Social and Cultural Rights, CSCR, is then comment in the 14 that the right to highest attainable standard of health as per Article 12. So the need to develop and implement a comprehensive national strategy of promoting right to health throughout their lifespan. So right to health, the CESCR recognizes that the outcomes of sexual health, that is also reproductive health, or shaped by underlying material and social determinants, that is the population groups across rural, urban contexts and religion and cultures. So it was the sex rights, sexual health rights, now reproductive rights. So the first formulation of reproductive rights as human right is found in the International Conference on Human Rights, which was held in Tehran in 1968. And further, the principles and aims of Universal Declaration of Human Rights, UDHR, was incorporated again. And so India was the part of that preparator committee and participated in the conference. So outcome of the conference was Proclamation of Tehran Final Act of the International Conference on Human Rights, 1968. So as per the Act, Section 16, it recognizes the human rights of couples to decide freely and responsibility on the number of spacing of their children and to have access to information and education to do so. So Principle 12 of the Declaration of Mexico, in continuation on the equality of women and their contribution to development and peace, retreats this of the couples and individual to decide freely and responsibility whether have children and when to do so, and to have the access information on. So for the education and would enable them to make these decisions. Again, in the Vienna Declaration, the program of action adopted the World Conference on Human Rights in 1993 emphasizes the rights of women on the basis of equality with the men to access the widest range of family planning services and to have adequate health care. So, definition of the reproductive, I think there is a loss of time, there is scarcity of the time to need not to discuss to the definition. This time comes the national scenario on that particular rights. So, reproductive rights as human rights have really been recognized since the International Conference on Human Rights Declaration in 1968 and the International Conference on Population and Development in 1994 and the International Covenant on Economic, Social and Cultural Rights 1996 and the Convention on the Elimination of All Forms of Discrimination Against the Women in 1979 and also foreground the focus on reproductive rights as necessary in realizing the human rights of women. So Sustainable Development Goals and the preceding Millennium Development Goals also encompasses several goals that directly as well as indirectly they are recognizing the reproductive rights of the human beings. In Indian scenario, हम देखते हैं Indian health system and the status of the sexual and reproductive rights. What is India signatory to these conventions and conventions? So,
Sagnatla ma'am, kindly come on the conclusion. We have partner.
Okay,
yes.
Sir. Okay. Just in conclusion, I would like to say that the abuse of human sexual and reproductive rights, which has been provided by the International Convention and the Constitutions, so these are due to deeply ingrained beliefs and social societal values that pertaining to the women's sexuality. So patriarchal concept of human role within the family mean that women are often valued based on their ability to reproduce only. So early marriages and pregnancy or repeated pregnancies, species to close together. So often as a result of effort to produce male offspring because of the preference for sons has a devastating impact on the women's health. So with sometimes fatal consequences. So women are also often blamed for infertility, suffering, ostracism, and being subjected to various human rights violation as a result. So recognition of sexual and reproductive rights of women still remains negligible. Reproductive rights in India are understood only in the context of selective issues like child marriages, female foeticide, sex selective, and natural health and hygiene. So because reason क्या है? Low public investment, poor infrastructure and government facilities, inadequately skilled resources. So still vulnerable women from the marginalized groups and the geographically remote areas or excluded from the health programs. So finally, I would like to say that the sexual and reproductive rights are essential to the realization of all human rights. So they encompass a spectrum of civil, political, economic, and social rights from the rights to health and life to the rights to equality of non-discrimination, privacy, information, and to free from torture or ill treatment. So promotion of these rights should be the fundamental basis for the governments and community-sponsored policies and programs. So government must consider the rights as a fundamental part of the laws when they enact any law or policy. They must keep women in the center of that, particularly their health and reproductive rights. Okay, thank you, sir. Any question?
Thank you so much, Dr. Shakuntala Sangam ma'am. Now we have the next presenter, Indrashis Majumdar. The title of his research paper is In Pursuit of Environmental Justice Through Litigation and Beyond. Over to you, Mr. Indrashis Majumdar.
Ma'am, Indrashis sir is not available. We'll move on with Vanas sir and Shikhar sir's presentation.
Okay, over to you, Mr. Shikhar.
Good afternoon. Am I audible?
Yes, you are.
Thank you. May I start?
Yeah, please go on. Okay,
Right. We'll just present our slides.
You can try to sum up within 5 minutes only, Shikhar. Don't take much time.
Thanks, sir. Go to the first slide. Correct. So, right, sir. I'll start in 3, 2, 1. Good afternoon, respected dignitaries, professors, and fellow students. I, along with Vanaj, feel honored to present our paper titled Mandatory Vaccination for COVID-19, Revisiting Jacobson versus Massachusetts. The central theme of the paper revolves around analyzing the Meghalaya High Court judgment on the controversial legal issue whether mandatory vaccination infringes on people's fundamental rights and liberties. We hypothesized that the said judgment is per incuriam, and the test laid down in Jacobson versus Massachusetts could be used as a yardstick to measure and legitimize the constitutionality of the mandatory vaccination orders. So moving on to our first slide and the most pertinent question, that why this research question of mandatory vaccination was chosen by us. The response is rather an obvious one. It is one of the most controversial legal issue in the status quo. For example, in December 2021, Australian lawmaker tabled a bill in the parliament to make COVID-19 vaccination compulsory for residents. In January 2022, as photo is describing, Australia denied visa to Novak Djokovic for being unvaccinated and effectively excluding him from defending the Australian Open title. Now, this is the gravity of the situation. The second picture in the slide is of Ottawa protests. Since January 28, Canada's capital has been under siege by convoy of angry truckers. The so-called Freedom Convoy is nominally protesting a vaccine mandate for truckers implemented in mid-January. These similar versions of mandate are visible in different corners of the world. And in India, states like Maharashtra, Manipur, and Meghalaya have also these similar mandates where shopkeepers, vendors, and taxi drivers were asked to mandatorily vaccinate themselves before reopening their business. Now, in relation to the same orders, the Meghalaya government passed the same orders. The High Court took a suo motu cognizance and held that mandatory vaccination is ultra vires the Constitution. The court further stated that vaccination administered by coercive methods vitiates the fundamental purpose of welfare attached to vaccination. We argue that this order deviates from long-standing jurisprudence and it further diminishes Indian jurisprudence by flawed reasoning. At least 25 state statutes empower authorities for mandatory vaccination. Several such legislation have also been passed the muster of judicial review before high courts. In the contemporary context of COVID-19, Section 2A of Epidemic Disease Act, read with Section 3 and 6 of National Disaster Management Act, empowers the authorities to enforce compulsory vaccination, which has been done earlier. So there is a precedent for the same. Now, moving on to the aspects of the judgment of why it is in per incurium would be dealt by my co-author Vanaj Vidyan. Giving the podium to Vanaj. Yeah.
Hi, I hope I'm audible, honorable members of the chair and respected panelists. I will continue from where Shikhar left off and analyze the Meghalaya High Court's judgment. So it is merely an 8-page order, and the High Court basically took up two grounds of Article 19(1)(g) and Article 21, which are respectively the freedom of movement and the right to personal liberty. Now, in Article 19(1)(g), the High Court merely stated that Article 19(6) is not applicable because vaccination is a matter of individual concern and not public order. This ignored the 2-month-old and a landmark judgment of the European Court of Human Rights in the case of Wawrinka versus the state of Ukraine. In the case of Wawrinka, the European Court of Human Rights recognized that there existed a legitimate aim, which is protecting health and the rights of others, and that there is a rational nexus between not allowing unvaccinated individuals in public and by preventing a viral outbreak. If you have a keen mind, you may have noticed that this is similar to the proportionality test that is applicable in India, which was derived from the Aadhaar litigation in the Puttaswamy case. And on this question of proportionality, the Meghalaya High Court's order failed to recognize that the Meghalaya government was only excluding a definite class of people like newspaper hawkers, whose profession necessitates public interaction, which means that if they are not vaccinated, they can end up becoming super spreaders. And therefore, since the court failed to indulge in a balancing of rights and directly rejected compulsory vaccination, is why we argue that this argument, that the court's reasoning is per incurium on the first question. As far as the second question on Article 21 is concerned, the Meghalaya High Court stated that the personal liberty of an individual was being restricted, which is why the order was unconstitutional. However, panelists, please note this 1905 case of Jacobson versus State of Massachusetts, the most landmark order on compulsory vaccination, which has stood the test of time for 116 years and was invoked even last year by Justice Chandrachud in the suo motu case that the Supreme Court had taken up. In the case of Jacobson, an individual was refusing mandatory smallpox vaccination, but the Supreme Court of the United States stated that mandatory vaccination was legal in light of public interest. It created a distinction between liberty and liberty regulated by law, and stated that in liberty regulated by law, there can be no injury that is caused to others. The great Justice Harlan noted that there is a lower threshold for liberty in times of great dangers, which things like the COVID-19 pandemic do qualify for as great dangers. So therefore, we come to the LAC 19 principles. We see that mandatory vaccination is legal, but just because it is legal does not mean that all states can blanketly adopt it. There needs to be satisfaction of the proportionality test, which is where the LAC 19 or the Lex Atlas COVID-19 principles come in. It is a project of an ongoing 200 jurists from around the world who are analyzing the various national legal responses to the pandemic. In October 2021, they adopted 93 principles divided into 7 parts. Here you see a summary that I have created of the 3 principles on the screen that are the most essential and form the crux of the LAC 19 principles. Firstly, that mandatory vaccination should coexist and can coexist with human rights such as the right to privacy and individual liberty. Secondly, that indirect mandatory vaccination, such as requiring people to be vaccinated to enter certain public places, must be codified. And thirdly, that the proportionality test, which was laid down by the European Court of Human Rights in Wawrinka and is similarly present even in India as far as the Supreme Court derived it in the Aadhaar litigation, must be satisfied. So mandatory vaccination must be proportionate to be allowed. And therefore, as I conclude my time and 5 minutes are over, we would urge everybody to get vaccinated because this pandemic won't end until everyone is vaccinated. So that would conclude my conclude our presentation by Shikhar and me, and we would be very happy to answer your questions. Thank you so much for your attention.
Thank you so much, Shikhar Yadav and Vanjan Vidan, for your insightful words about COVID-19, that we should be vaccinated, right? We should all be vaccinated. Thank you. Thank you for your wonderful points. Over to you, sir, Dr. Abhishek Tiwari, sir, please. We have completed all the presentation.
Thank you, Meenakshi. So I feel privileged to be part of such a wonderful presentations. With the permission of our chairperson, Professor Sudarshan Verma, I would like to present my views.
Definitely, Abhishek. Please say something.
Thank you, ma'am. Thank you. So this wonderful discussion started with the ice-breaking session of Mr. Shikhar Gupta that was regarding the contours of right to health, in which he discussed about the various aspects of right to health and the national and international perspective. Right to health related issues in Constitution and the foundation of right to health in the judgments of Supreme Court. Later on, Ms. Smriti Singh and Divya Dwivedi presented the important aspects of role of WHO, World Health Organization, in enforcing right to health, and the COVID-19 effect on the right to health and its scenario. The important aspect was covered by the issue of dissemination of information and coordination by WHO. After that, Ms. Sonakshi Narula and Jyoti Sharma presented their views on pandemic and the ground realities of healthcare facilities in India. They have focused on the rural and urban health issues and the Indian scenario regarding that. The next presenter was Ms. Sarita Sharma. She presented all the different but correlated health topic with the right to health, with the health of the financial health of the nation, the state, and that results in the health of citizens. Later on, Mr. Sufyan Khan presented his views on the issues of climate change and climate justice. After that, Ms. Namrata presented about the issues of environmental and climate justice for all citizens and the important instruments at the international level regarding climate change. After that, Dr. Sakuntala Sangam presented the important aspect of right to health with the perspective of sexual and reproductive health rights. She has presented the international and the national scenario regarding right to health. After that, in the last, Mr. Shikhar Yadav and his co-author, they presented about the issues related to mandatory vaccinations and the Meghalaya High Court judgment and its pros and cons and the legality. So with this, I can say at the juncture that the issue in this first technical session regarding right to health has been presented and discussed with full justification, and the burning issues related to COVID-19 and perspective thereon has been discussed thoroughly. So I congratulate all the presenters. I thank the organizer of this seminar, Dr. Prem Kumar Gautamji, for giving me this opportunity to be part of the gathering, this particular discussion. Thank you very much. Over to Meenakshi.
Thank you so much, sir, for your valuable words and insight on this technical session of this seminar. Ma'am, would you like to say some words?
Definitely, I would like to say something. I would like to throw some light on the seminar conducted by you people, and topic chosen by you for the seminar, that is emerging issue in law and justice in the perspective of globalization. When we talk about the justice, it is a very big, very dynamic concept, and covered all the aspects of social, economic, and political justice enshrined in the preamble of the Constitution of India, which declares the objective to secure all its citizen justice, social, economic, and political, which government of India is to achieve through its laws and policies. And being the welfare state, it is the duty of the government to provide the all facet of the or facilities of the healthcare to its citizen, to ensure the health justice, because health justice is also one of the essential part of the word justice. Although during last more than 74 years of the journey of independence, many have been done by the government of India to ensure right to health to its citizen, not only in the urban areas, but in the rural areas too. However, these efforts were not sufficient to provide right to health to all its citizens, for achieving the dream for the dream of the right to health to the poor or illiterate or rural people. It become more difficult to achieve after the privatization. Right to health become more right to health to achieve the right to health become more difficult after the privatization of medical facilities. As we know, now doctors are become businessmen and part of the medical corporate system, and the we can say the medical treatment or medical facility to avail the medical facilities become more and more difficult to the poor people and to the rural people. And this is in this situation, we can say that the objective of the Constitution is not being achieved by the government, and it is still a dream for the so many people. And we have seen the situation during the during last 2 years, when lots of the people or thousands or lakhs of the people lost their life due to non-availability of the medical facility during the pandemic, particularly in the time of the complete lockdown, when not only the COVID-19 patients have been died, but so many other people who were affected by the some infectious disease, some other severe disease like cancer, like TB, like the AIDS, which can be cured by the availability of the medical facility during all these pandemic time. But so many people lost their life, not only due to the COVID-19 pandemic or COVID-19 infection, but due to non-availability of the medical facilities these days. And all the medical infrastructure, we can say ki we have seen the the government facilities which were provided by the government to the public for taking care of the COVID-19 pandemic or to the patients of affected from the COVID-19 viruses. So these were failed, and therefore it is the very burning issue nowadays that the government should take the more and more initiative in the area of the health care system, particularly public health, and government should not leave this area or the health system in the hands of the only public or private sector, but public sector must be strengthened by the government. So with these words, I would like to congratulate to all the participants of this sessions who presented very good papers covering almost all the aspect of right to health, from right to health, right to health infrastructure, role of WHO, COVID-19 pandemic, during COVID-19 pandemic, vaccination in pandemic, to health environment, including healthy environment, including reproductive health rights. So congratulate to all the presenters of the papers who have presented good quality of paper. I would also like to congratulate to the organizers of the seminar, Dr. Prem Kumar Gautam and his team members, including student members, who organized this seminar on very significant topic in very well manner. In the last, I would also like to congratulate to Dr. Abhishek for achieving the new heights in its academic career. He has recently joined Lucknow University as a post of associate professor. So congratulate Dr. Abhishek. And last but not the least, I would like to thanks to the organizers for giving me this wonderful opportunity to chair the session and to express my views on the on this topic. So thank you to you all, and thanks. Thank you very much.
Thank you so much.
Thank you, ma'am. Thank you all.
Thank you so much, ma'am, for your encouraging and motivational words. Over to you, Akshat. Yeah.
Thank you very much, ma'am. I would like to call Ms. Meenakshi, ma'am, to give the vote of the thanks for the session.
Thank you, Akshat. Very good afternoon again to one and all. Nothing brings me more joy today than to conclude the technical session 1, protecting the right to health issues and challenges. I formally thank all those who have contributed with their time and thoughts towards this event and its happy conclusion. I would begin by extending my gratitude to our Honorable Vice Chancellor, Professor S.K. Bhatnagar, for always providing us with the space and encouragement to host events like these, and thereby enabling fruitful and intellectual discussions. Our deepest gratitude to Professor Dr. Sanjay Singh, Chairperson Committee, Dr. Ram Manohar Lohia, National Law University, and the other members of the committee. The event would not have been the light of the day without thanking our guest for the morning session, technical session. Our deep gratitude and appreciation to Mr. Shridul Gupta for throwing light on effective implementation of right to health and the indispensable role for implementation for fundamental and human rights. Thank you, Mr. Shikhar Yadav, for reminding us that it is important to formulate the laws. It is equally important to implement them and be aware of it. I thank Ms. Smriti Singh and Divya Dwivedi to throw light on COVID-19 topic and the importance of funding and throwing light on the absence of international organizations, importance of international organization, the can say for not taking COVID-19 or pandemic such a situations very seriously. Thank you, Sonakshi, for throwing light on health infrastructure in India and the role and throwing the light on lack of medical stores and technological challenges that India is facing right now. I would like to thank Mr. Muhammad Sufian Khan, who talk about all-round development of the society and environmental concern. Miss Namrata Patel, who throws light on climate change, importance of environmental disparity, care for less emission things and all. Last but not the least, Mr. Shikhar Yadav, Vanjana Vidyan, Dr. Shakuntala Sangam for presenting your paper and have given up your valuable words for this event. Thank you all for your precious time and words. Our deep gratitude and appreciation to our organizing committee. I would also thank the umpteen people who have contributed towards the actualization of the event, without whose consistent and constant efforts this would not have been possible. Thank you to one and all. With this note, I would request the moderator to kindly take over. Over to you, Akshat.
Thank you very much, ma'am. Thank you for the co-chairpersons and the chairperson to be present in the meeting to see over the technical section. I would like to request you for this of the.
Thank you, Akshat. Thank you so much.
Thank you, Akshat. Thank you, Meenakshi.
Thank you, ma'am. Thank you, Abhishek ji, for gracing the occasion, ma'am. Thank you, sir.
Thank you, ma'am.
Thank you, sir.